Welcome. Thank you all for being here today. For those of you who do not know me, I am Eddie Weeks, your legislative librarian. Your legislative library is just across the hall here in Suite 804. Please stop by and say hi at any time. I'm there to answer just about any historical question you may have about the legislature, old acts, prior legislation, past legislators, the legislative process, and even what is the history of the ratifications of the 13th and 14th Amendments in the state of Tennessee? What a great question. This presentation is, in many ways, a continuation of the previous one on the history of the Tennessee State Capitol in the Civil War. That talk was focused more on the executive branch, the governors before, during, and after the Civil War. This talk will focus more on the legislative branch. In fact, a better title for this talk may have been Expelled, the Tennessee legislature from 1865 to 1867, because that's what happened. Members were expelled. The Speaker of the House stepped down. Members were locked in the committee rooms. The sergeant at arms was arrested. A judge was impeached. And the handrail on the first floor of the Capitol was shattered by a gunshot, all over 2 amendments to the federal Constitution. But these are rather important amendments. The 13th Amendment, submitted by Congress to the states on February 1st, 1865, neither slavery nor involuntary servitude, except at punishment of a crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. The end of slavery. The 14th Amendment, submitted by Congress to the states 1 year later, June 16, 1866. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Why is this one so important? Remember from the last talk, the Dred Scott decision. In 1857, the United States Supreme Court declared that, persons of African descent cannot be, nor were they ever intended to be, citizens. Less than 10 years later, this proposed amendment will overturn that decision, and all former slaves and all persons of African descent will be citizens and guaranteed equal protection under the laws. On March 4th, 1865, the loyal Union voters of the state elected a new governor and a new legislature. It was the return of civilian government after 3 years under military governor Andrew Johnson. The districts of the members were based on the 1852 reapportionment. Things were a little bit too busy in 1862 for the state to be properly reapportioned. But remember that only loyal Union voters could vote, and some areas were more loyal and more Union than others. The solution was 9 additional members of the House, increasing the membership of the House from 75 in 1861 to 84 in 1865. Still 25 members of the Senate, but now 84 members of the House. The loyal Union counties were rewarded, mostly the northeast Tennessee counties, plus Macon County in Middle Tennessee. There was also an unintended consequence of this action. It increased the number needed for a quorum from 50 House members to 56 House members, 2/3 of the membership. But of course, that would not be an issue over the next 2 years. All the men elected to the new General Assembly were elected on a slate under the Union and Reform ticket. That is, you didn't vote for an individual member of the General Assembly. You voted for or against all of the approved candidates. The 25 members of the Senate and the 84 members of the House. No candidate had an opponent. the slate of candidates were elected and the legislature convened in that building on April 3rd, 1865. Why is that date significant? Because the Civil War did not end until May 13th, 1865. That legislature convened in that building while the war was still being fought. Remember that the last legislature that convened in that building during that war had to flee that building during that war. On Wednesday, April 5th, 1865, 2 days after convening, the 34th General Assembly of the state of Tennessee ratified the 13th Amendment to the federal Constitution. That language was already in the state constitution as amended by a vote of the people in February. There were a few problems along the way, though. On May 3rd, 1865, Representative David McGahey resigned his office on account of bad health. He was not the only member who did not serve out his term in office. In fact, of the 84 House members elected, only 76 ever took office in 1865. On May 5th, 1865, Representative Joseph Dillon of Giles County resigned, and Representative William Mullenix was granted a leave of absence for the next 10 days. In fact, there were several leaves of absence granted to members and to the doorkeeper throughout this session, which caused a few problems when they got too near that 56-member quorum. Still on May the 5th, Representative Jeremiah Gilmer was granted a leave of absence before Representative James Hood moved to reject all applications for leaves of absence. Representative Pleasant Williams then moved to grant no leave of absence that will reduce the House below its quorum. 62 members voting, just 6 members over that quorum. The Nashville Daily Union on May 6, 1865, reported on the number of members being granted leave and then reported that Representative Henderson had said that the legislature was in its 5th week of session and had done absolutely nothing, not counting the ratification of the 13th Amendment, of course. That legislature then recessed on June 12, 1865, after convening on April the 3rd. The members then reconvened on October 2nd, 1865, the regular meeting time of the legislature. They then met from October 2nd, 1865 until May 28th, 1866, 8 months in regular session. Things did not go well. Remember, these were the same members elected in March 1865, and when they reconvened, they had a few more problems with their membership. Representative Charles Cameron was declared not entitled to a seat and was removed from the General Assembly. Representative J.M. Tomney, elected in March 1865, never showed up for any session, and his seat was declared vacant. October 31st, 1865, the House adopted House Resolution number 30, mentioning that the House has frequently been reduced below a quorum, and declaring that any member absent without permission would not receive a per diem for that day. It was not just a House problem. The Nashville Daily Union, November 4th, 1865, pointed out that there was no quorum in the Senate the day before. The only solution, if a member refused to show up, was to declare his seat vacant and have the governor issue a writ of election for a new member to be elected to replace the absent member. On November 22nd, 1865, the House decided that they had to have a list of their current membership. They were getting confused too. The 34th General Assembly then recessed for the Christmas and New Year's holidays. They returned in January 1866, and in January 1866, The seat of Representative Alvin Gillum was declared vacant, and Representative J.H. Travis simply resigned his seat in the General Assembly. The Senate, meanwhile, was wondering what they could do while the House had no quorum. They even appointed a Senate committee to try and figure out what actions they can take while the House can do nothing. And the House kept kicking out the members who weren't attending, requiring more special elections to replace those members. Representative James Hood is an interesting case because he did show up and was seated in the House. And the House then said that he has on several occasions insulted this body by taking up his hat and cane and leaving the House in order to reduce its members below a quorum. Eventually, the pressure even got to Speaker William Heiskell, who had to take his own leave of absence. He did manage to sign the resolution himself before taking a few days off, and a Speaker pro tem of the House was elected. They finally adjourned May 28, 1866, but planned to reconvene again in November 1866, and finally adjourned sine die in December 1866. They had already been in session for 8 months, plus April to June 1865, and they needed a break, not to mention their staff. But Governor William Brownlow had other ideas. On June 19, 1866, the month after they had adjourned, Governor Brownlow issued a proclamation for the men to reconvene in an extraordinary session on July 4th, 1866. This was the first extraordinary session of the 34th General Assembly, and what they were to consider was the proposed 14th Amendment to the federal Constitution, submitted to the states June 16th, 1866. On July 4th, 1866, the House convened and adjourned for the day without taking roll, in order to permit all of the members present who desired to do so to participate in the celebrations of the day. On July 5th, they took roll. 43 members present, 13 members short of a quorum. Representative M.E.W. Dunaway then resigned his seat on July the 5th, and his resignation was refused by Governor Brownlow. As it is evident, the design of your resignation is to reduce the House below its quorum and to break up the legislature. The same is not accepted. On July 5th, 1866, the doorkeeper was instructed to telegraph the absent members, requiring their immediate attendance. And day after day passed with no House quorum. The Senate, meanwhile, completed its organization and began its business without the convening of the House. The Senate could pass whatever they wanted, but nothing could pass the House without a quorum. On July 9th, 1866, there were 55 House members present, but 56 needed for the quorum. Representative James Mullins then offered a resolution directing Speaker of the House Heiskell to issue warrants of arrest for the refractory members of this House, and that Captain William Hite, as Sergeant-at-Arms, be authorized to employ such assistance as may be necessary to bring said members before this House. But without a quorum, could the resolution actually be adopted? Regardless, on July 12, 1866, Sergeant-at-Arms William Hite issued his report to the House in which he said he could not find any of the missing members. But as I shall not relax my vigilance, I yet hope to secure their attendance in this House. And the House adjourned for the day, still with no quorum. More names. and more warrants for arrest for the missing members. And on July 16, 1866, Sergeant-at-Arms William Hite reported on sending 2 deputies to Carter County to arrest Representative Pleasant Williams. Proceeding thence, partly on mules and partly on foot, they arrived at Mr. Williams' residence about midnight, arrested him, took him to Carter Station, and thence brought him quietly to this city and to this house where he now is. The next day, July 17th, Sergeant-at-Arms Hite reported on the arrest of Representative A.J. Martin in Jackson County. I would also report Mr. Martin is now present. Thursday, July 19th, 1866, the 15th day of session with no quorum. 54 House members present, 2 short of a quorum. And then, Mr. Mullins moved that Mr. Williams and Martin be invited and required to take their seats within the bar of the House. 56 members present. The members arrested were locked in the committee room, the rooms that are now the offices of the clerk around the House chamber. Representative Arnell remarked that with the 2 members who were in the committee room under arrest, there was now a full quorum in the House. The prisoners were then invited to the floor. Immediately, the House took up Senate Joint Resolution 2, ratifying the constitutional amendment. And on July 19th, 1866, the 14th Amendment to the Federal Constitution was ratified in that building by a vote of 43 ayes, 11 noes, and 2 present not voting, the 2 members who were still under arrest in the committee rooms. But it was still not over. Note that Speaker of the House, William Heiskell, voted against the ratification. Governor Brownlow, though, immediately telegraphed Washington that Tennessee had ratified the 14th Amendment. And as for the 2 members still under arrest in the committee room, Mr. Ralston said that he was decidedly in favor of having them retained under arrest as a just atonement for the offended dignity of the House. Mr. Norman thought that the dignity of the House had been fully sustained and that there was no further necessity for keeping the prisoners in confinement. Mr. Richards took the same view of the matter and earnestly urged the release of the imprisoned parties. On the vote being taken, the vote stood for releasing the prisoners 39, against it 10. The Speaker decided there was no quorum present. Mr. Norman suggested that it was rather hard if less than a quorum could imprison the men, and that it took a full quorum to release them. Pending the discussion of the subject, on motion, the House adjourned for the day. Meanwhile, Judge Thomas Frazier of Davidson County had issued a writ of habeas corpus to free Representative Williams from his imprisonment in the House chamber. Sergeant-at-Arms Hite refused to release the man, and Judge Frazier then ordered Sergeant-at-Arms Hite to be brought before him to face charges of contempt. The Daily Union and American on July 20th, 1866, reported on the ongoing cases involving Judge Frazier, Sergeant-at-Arms Hite, Representative Williams and Martin, Davidson County Sheriff Patterson, and Deputy Sheriff Shaw, and their posse. Sheriff Patterson first encountered the deputy of Hite who had Mr. Williams in custody and ordered him to surrender the prisoner at once. He said that he would not do so. Deputy Shaw told him that if he did not obey the writ, he would summons a posse of men and take him by force of arms. He then showed the sheriff where his deputy and the deputy where Mr. Williams was. They took possession of Representative Williams as directed in the writ and brought him before Judge Frazier, who discharged Representative Williams from custody. These actions by the sheriff and by the judge did not go over well with the membership. But what about Representative A.J. Martin, who was still under arrest in the committee room? Judge Frazier issued another writ of habeas corpus demanding that he be freed. The Memphis Public Ledger, July 20th, 1866, a kettle of political fish, members released, suits against members instituted, the Speaker in the Journal, the dignity of the House insulted. About 4 o'clock this morning, the sheriff, with a posse of policemen of some 30 men, found their way into the Capitol and arrested Height, Sergeant-at-Arms in the House, carrying him and his prisoner before Judge Frazier to answer a writ of habeas corpus. Representative Martin was released and Height fined in costs some $10. Representative Williams was found last night and released from arrest. On July 23rd, 1866, 58 members present, but not Representative Williams or Martin. And on that day, Speaker Heiskell objected to the actions of the House, declaring that Representative Williams and Martin, though in the committee room, were under arrest and refused to vote, and there was no quorum on July 19th. And he refused to sign Senate Joint Resolution 2, the resolution ratifying the 14th Amendment. The next day, Representative Frank Smith moved that the Speaker be most respectfully requested to append his official signature to the resolution. Speaker Heiskell again refused, and Representative R.S. Ralston then offered House Resolution 14 to remove the Honorable William Heiskell from his position as Speaker of this House, and the House adjourned for the day without voting on the resolution. The next day, Representative Ralston withdrew his resolution, and Speaker Heiskell asked that he might be relieved from the duties of the chair and that a Speaker pro tem be elected. Representative John Norman was then elected Speaker pro tem of the House, and it was he who signed Senate Joint Resolution 2 ratifying the 14th Amendment. And then, on July 24th, 1866, the members who had refused to attend the session and those who kept disappearing during that session were then expelled from the House, one by one, in a series of votes. The Union flag. The House of Representatives on yesterday afternoon vindicated its dignity and punished the crimes of contumacy and conspiracy by expelling by a vote of more than 3-1 the following members: Martin, Williams, Porter of Henry County, Foster, Brittle, and Marable. Every lover of the law will heartily applaud this most just, dignified, and necessary action of the House. Most justly have the offenders been driven from this House. Meanwhile, the House took action against Judge Thomas Frazier, Sheriff Patterson, and Deputy Shaw. They were to appear before the House in November 1866 when the legislature reconvened, and the purpose of their appearance was the impeachment of Judge Thomas Frazier. And in May 1867, the Tennessee Senate convened as a court of impeachment to consider the actions of Judge Thomas Frazier. The Nashville Union and Dispatch, May 16, 1867, reported that the Senate was in the 8th day of the trial. May 31st, the 21st day of the trial. The Nashville Union and Dispatch, June 2nd, 1867, reported that Prosecutor Ewing said, "We have to decide, not merely in this case, but for all after time, that no one holding the office of a judge may invade the rights of the legislature of Tennessee." The Nashville Union and Dispatch, June the 4th, 1867, reported the words of Speaker of the Senate Joshua Frierson. "I am constrained to declare Thomas N. Frazier, Judge of the Criminal Court of the County of Davidson, removed from office and disqualified to fill any office hereafter in the state of Tennessee." But what was done was done. On July 24th, 1866, Tennessee was readmitted to the Union because of its ratifications of the 13th and 14th Amendments to the federal Constitution. What you may not know, though, is that the Capitol still bears a little reminder of this very time. It's best explained in the self-guided walking tour of the Capitol produced by the State Museum. Halfway up the first flight of stairs on your right is a chip in the handrail. This is a scar from a bullet fired from the stairs above during a particularly bitter fight in the legislature over the ratification of the 14th Amendment. The amendment, which granted citizenship to African Americans, was opposed by many in the General Assembly. They didn't have enough votes to block passage of the amendment, so they attempted to flee armed guards so there would be no quorum. The guards' willingness to shoot changed that strategy, and the amendment passed, allowing Tennessee to be the first Confederate state readmitted to the Union. And so, the Capitol still retains a scar of its time in the Civil War and the time of the ratifications of the 13th and 14th Amendments to the federal Constitution. And ladies and gentlemen, that's all of my time. Thank you for your time.